Right, we're going to call the meeting to order. Looks like it's 10:01. Just again, would ask everyone to mute their microphones, only turn them on when you speak. Especially in this forum, we would appreciate you announcing your name when speaking so that we can be sure and be able to identify you for the record. Again, greatly appreciate everyone making time to be here. Very much appreciate us having a quorum. We do have several important things to cover. Ms. Lopez Sparks, if you would mind, please taking roll and determine. Sounds like we have a quorum already determined, but if you would mind taking roll, please.
Yes, sir. Jackie Cooper. Richard Davila.
I'm here.
Gary Hahn.
I am here.
Amy Trost. Uh-oh. Oh, she is. Okay. TJ McDowell. Deidre Stewart. Dustin Potter.
I'm here.
And Lance Brooks, presiding officer.
Here.
You have a quorum.
Thank you.
Mm-hmm.
So since we do have a new member, and to remind those of us that have served on the board already a little bit, Ms. Wendy Pello has a training for our advisory board members. Ms. Pello?
Thank you. Good morning. Wendy Pello, Senior Assistant General Counsel. This is our training that we do when we have new members, but also, as the chair mentioned, just as a periodic training and reminder of kind of the key acts that we want to be paying attention to. I'm going to share my screen here. There we go. Are you all able to see the screen and see the slides? Okay. This is training. We wanted to spend a few minutes talking about the Open Meetings Act, the Administrative Procedure Act, and the Public Information Act. You do have materials in your, or information in your materials. So this was just kind of more of a highlights overview of these three acts, but you do have handouts and takeaways so you can refer back to those as well. The first one we wanted to talk about was the Open Meetings Act. And the purpose of the Open Meetings Act is to ensure open and transparent government, and it requires meetings of governmental bodies to be open to the public and preceded with public notice so that the public knows the time, place, and subject matter that will be discussed at that meeting. And the act is mandatory, and it's construed liberally to be in favor of open government. There's a few key concepts in talking about the Open Meetings Act. The first being quorum, and a quorum is the majority of the members of the governmental body, or in this case, the advisory board. For this board, there's 9 members, so a quorum is 5. You do have quorum today, so that's not going to be an issue. A quorum is needed in order to take any official action, take votes. If less than a quorum meets, then the board can have the discussion, but they're not going to be able to take any official action. Another key concept is deliberation, and another word is just discussion. And that discussion, which I think is important for you to know, it can be verbal or written, and it's among a quorum of the governmental body or between a quorum of the governmental body and another person concerning an issue that's within that jurisdiction of the governmental body. So again, it's important it's discussion, both verbal and written. Meetings is another key concept, and this can occur anytime that there's a quorum engaged in a discussion over issues that are before that governmental body. And I think the key to here is in this kind of setting, whether it be video conference or in-person meetings like this with properly noticed, it's kind of obvious in terms of Open Meetings Act, but it's important to remember that it can happen anytime a quorum is together. Quorum of the advisory board, quorum of the governmental body is together and having a discussion. And the fourth key concept is notice, and this is making sure that that there's advance notice to the public about the time, place, subject matter of those meetings. We're required to have those posted at least 7 days in advance of the meeting. And the other key concept is that agenda is identifying what the subjects that will be discussed at that meeting, and we need to stay on that agenda in terms of just our discussions. This slide is just a reminder about social functions and conventions. Obviously, as they're saying, meetings can occur in a variety of places, and this is slides that's talking about being mindful if you're at a professional conference, social gathering where you've got a quorum of the members there, that that discussion could be subject to the Open Meetings Act if you're having a discussion about board business. So don't have those types of discussions about board business in those type of settings, because again, those types of discussions in those types of settings would be subject to the Open Meetings Act. And so just some key points to remember: always be aware of the situation in which a quorum is present, and don't engage in substantive conversations relating to board business when a quorum is involved and you're outside of an officially noticed and scheduled meeting. The next issue is walking quorum, and a walking quorum occurs when there's fewer members than a quorum that are involved. It might be a work group, it might just be a conversation two board members are having. It's less than a quorum, you can have that discussion, but what happens is when one or more of those members has the discussion with others beyond that initial conversation or initial exchange or discussion, such that the conversation walks to more members, such that you hit a quorum. In the sense that the walking quorum is the discussion's kind of walked into a quorum. And this slide is an example where you've got 5-member advisory board, 2 members having a conversation, one of them then subsequently exchange, either phone call, email, however, communicates that to a third, and now you've got a walking quorum. And those walking quorums can occur in a variety of settings, conference call, video conferences, email, text, various social media, postings on various social media pages. And so here's some best practices to avoid that walking quorum is don't meet in small groups, have a discussion, and then communicate those discussions with other board members. Send emails or text messages to a quorum of members, and that can, even if you send them emails individually, but you send it to a quorum, even though they weren't on a group email, they're sent individual emails, you still have that same issue. Don't create posts on social media about board business where quorum of members could participate in that discussion. And then the other is don't ask a quorum of members, even if you're asking on an individual basis, for feedback or comments about a certain issue that'll be on an agenda. That's kind of called polling. And it's, you're trying to get a kind of a feel or a vote outside of a properly public meeting, notice public meeting. Guidelines for open sessions. So this happens when we're actually in the meeting, is keep those discussion limited to the items that are on the agenda. During the public comment portion of the meeting, members of the public are given opportunity to speak, and they can raise issues that are on the agenda or not on the agenda. If they're raising an issue that's not on the agenda, the advisory board can't have a discussion about those public comments. If you're wanting to discuss it, you can put it on the agenda for a future meeting, for it to a work group, let staff handle it. But you can't have the discussion there. It doesn't mean you can't ever have a discussion, it's just not there. And that's because the public hasn't been noticed that you would have a discussion about whatever that matter was. Guidelines for and some best practices is limiting the discussions to the specific agenda items, not allowing the discussion regarding those items to kind of wander off course into new issues. Don't respond or discuss issues during public comment that aren't on the agenda. And then if you do have, like I said, have items that you'd like to discuss in the future, when we get to that point in the agenda, we can add items as well for future discussions and future meetings. And the Open Meeting Act does have civil remedies in terms of any of the actions taken by the board. They're voidable and they can be voided if there's been a violation of the Open Meetings Act. And then there's also criminal penalties, which involves fines from $100 to $500 and confinement in county jail 1 to 6 months, or both. And that's for members who knowingly participate in a quorum or participate in a meeting that's closed to the public. So again, just to kind of takeaways: avoid communications that involve a quorum about official business but are outside the properly noticed public meeting, and then during the meeting, confine your discussions to items that are on the agenda. We have resources here, and these same resources are included in your materials as well. The Administrative Procedure Act, also known as the APA, this is the statute that governs kind of the standards for uniform practice and procedures for state agencies. And part of that statute includes rulemaking. And so for purposes of our discussion, just talk about the rulemaking process. And again, it's having public participation and transparency during the rulemaking process. The rule is a statement of general applicability that implements, interprets, or prescribes law or policy, describes procedures or practices of the agency, but not internal procedures, but how practices and procedures in terms of working with like the licensees and like, here's the rules for how you would apply for a license, how you renew a license, various, when we get to rules later, you'll see kind of setting out those requirements. Rules can include new rules, amendments to existing rules, or a repeal of an existing rule. There's a variety of resources or a variety of ways rulemaking can happen. Legislative changes, we'll have an agenda item later on the agenda talking about rules that will implement a bill that passed this past legislative session. Advisory boards and TLR staff can be sources for ideas for rulemaking. The 4-year rule review, we do have an agenda item later on today's agenda regarding the 4-year rule review. And this is where all state agencies are required to review their rules every 4 years to make sure that they're still necessary, the reasons why you adopted them still exist, do they meet legal and policy considerations, do they reflect your current procedures. So we do that review every 4 years. So that can be a way of gathering information both from the public, the licensees, department staff. And then the last way is a rule petition. And that's where someone who's a Texas resident, a business in Texas, governmental subdivision in Texas, or a public or private organization in Texas can submit a petition to the agency requesting adoption of a rule. This chart right here kind of sets up a high level kind of flow chart of the rulemaking process. When you go through, you start from this top left corner in terms of the ideas, internal reviews, review by the governor's office. These two blue boxes here show where the advisory board shows up in this process for TDLR. For this first blue box on the top line is the first advisory board. And so we, later on in this agenda today, we'll have rules. And this is where we're in the process here is presenting the rules to the advisory board, getting your feedback and input, and then getting a recommendation from the advisory board in terms of publishing those proposed rules in the Texas Register and getting the public comment for 30 days. So we have 30-day public comment period. We'll review after the public comment period ends, we'll review those public comments, and we'll come back for a second advisory board meeting. We'll bring those proposed rules, the public comments received, any changes the staff think that may need to be made based on those comments. Again, have another discussion with the advisory board. And at that point, we'd be getting a recommendation from the advisory board to the commission for adoption of those rules. And that those rules would be adopted by the commission at a public meeting. Adoption filed and published, notice filed and published, and then those rules will take effect. So this is a very high level overview of kind of that rulemaking process. This next slide is talking about the rule review process as a whole. Again, I said you've got all of our rule chapters are on a 4-year schedule. We do the notice of intent to review, and at this point, we're putting the public on notice that we are reviewing these rules pursuant to the 4-year rule review, but there's not any proposed rules at the time. You don't see the usual underlines and strike throughs that you might see in a standard rulemaking. And then it goes to the public, again, has an opportunity to comment on that and submit comments as well. Our agency, the General Counsel's Office, is reviewing those rules, reviewing the public comments, reviewing the rules according to what we need to do according to the Administrative Procedure Act. We're reaching out to the divisions, getting their input as well. The rule chapters then go to the commission for their consideration. At this point, they're not making any changes. We're not proposing or adopting any changes because the public hasn't seen anything changed, but this is up for consideration of readopting the rule chapter. And then any public comments that were received or the input that the department staff have identified of any issues, we'll bring those to the advisory board. And this is this last box here. Scott's Orange Boxes, we'll have that kind of conversation as well later on our agenda of bringing the ideas that were generated out of that rule review process. And are there any changes that need to be made in a future rulemaking? So that's kind of that process there. And again, we have rulemaking resources, and those are in your materials as well. And the last is the Public Information Act. And again, this is allowing the public access to information about the affairs of the governmental body and the official acts of the officials and its employees. It's sometimes known as the Open Records Act, and commonly known as terminology. The Act does make all documents, records, and other information relating to official business open to the public with certain exceptions. And it includes any information, any electronic communication created, transmitted, or received or maintained on any device as it relates to official business. And again, construed liberally in terms of granting requests for information. One of the things when the department receives a Public Information Act request, it has to be in writing. The is time sensitive. This in terms of responding to those requests. The agency has to respond as soon as possible, but not later than 10 business days. One of the things we want to make our advisor boards aware of in case you get a request, somebody requests, since they know you're on the advisor, requested documents to you, that needs to just be sent to the department. We'll handle that response, but want you all to know about it in terms of the time sensitive nature, because not only are we collecting the documents at that point, but if identifying if there's anything that needs to be redacted, or if there's any requests that need to go to the Attorney General's office in terms of requesting that certain information be kept confidential. Again, I said there's a general rule of presumption of openness, but there are certain exceptions of things that must be redacted, like things like date of birth, some email addresses, certain educational documents, HIPAA information, medical records information as well. So there's things that must be removed as well. And then there's some that need to seek a ruling from the Attorney General's office on. So those are some highlights. Again, you've got resources here and in your materials, but that concludes the training. So thank you very much for your attention.
Thank you for providing that. And I just would go on to say that I really appreciate you, Ms. Pellos and Ms. Lopez Sparks, for all of your time that you've given me over the last few weeks and trying to make sure that I can do my part in doing a good job. Thank you very much for all the materials and time that it goes into preparing for these meetings. And once again, I'd also say thank you to the board members that are here so that we have a quorum and we can conduct business on the behalf of the people of Texas. Would ask at this point, the minutes were included in the materials that Ms. Lopez Sparks sent out. I would ask if there's a motion to approve the minutes for August 6th of 2021.
Yeah, I would like to make a motion to approve the minutes as detailed from our meeting Wednesday, August 6, 2021.
So I believe that was Mr. Davila who made the motion. Is there a second?
Amy Trost, second.
Thank you, Ms. Trost, seconded. Ms. Lopez Sparks, would you mind polling the members for their vote?
Yes, sir. I just wanted to also mention that Deidre Stewart is also online. She doesn't have video, but she hopefully can hear her. Ms. Stewart, can you hear us okay?
Yes, I can hear fine. Thank you.
Perfect. All right.
Thank you for being here, Ms. Stewart.
Okay.
Thank you.
Mr. Richard Davila?
Aye.
Mr. Gary Hahn?
Aye.
Ms. Amy Trost? Aye. Ms. Deidre Stewart?
Aye.
Mr. Dustin Potter?
Aye.
And Mr. Lance Brooks, presiding
Aye.
officer. Motion passes.
Thank you. So we move on to item E, the public comment. Based on the notes from Ms. Lopez Sparks, it appears that we have no public comments related to the topics at hand. Is that correct, Ms. Sparks? Lopez Sparks? Excellent, excellent. So if there's no comment, then we'll move on to the staff reports. The licensing division, Mr. Leonard Rivas, if you wouldn't mind giving us a report, please, sir.
Yes, sir. Good morning, advisory board members. My name is Leonard Rivas. I'm with the licensing division. You have a copy of the licensing report in front of you with your packet. but I will go over the third quarter numbers for the program. So for hearing fitter instruments, we issued 9 new licenses, 80 renewals, and the total population 690. Apprentice permits, we issued 14 new licenses, 1 renewed, and 44 at the end of the third quarter is the current population. Temporary training permits, we issued 23 new temporary training permits. We renewed 9, and the total population at the end of the third quarter was 112. I'm going to go over briefly the emergency license extension update. On November 23rd, 2020, the commission met and passed an emergency rule relating to the COVID-19 pandemic. Under this rule, all TDLR licensees with a renewable license that expired on or after August 1st, 2020, and before or on September 18th, 2021, will be considered to hold an emergency license valid for up to 120 days after their expiration date. Regarding the emergency license extension, we are referring customers to our website for their extension information and to check for any additional updates. That concludes my licensing report. I'll be happy to answer any questions if you have any.
Any questions? Thank you very much. And
All right,
we
thank you.
certainly recognize a few challenges with COVID and people working remotely and the mail system. So thank you very much for all your efforts on that.
Yes, sir. Thank you.
Let's move on to the customer service division. Ms. Mary Winston, if you wouldn't mind giving us an update, please.
Sure. Sure. Good morning. Mary Winston, TDLR. This is not my typical report, but as I go over personnel changes, I'll give you that update. After 15 years of service at TDLR, our Director of Customer Service, Mr. Trey Seals, I think he has 20 plus years with the state of Texas, has moved on to pursue other endeavors. We wish him all the best. The impact that he has had cannot be overstated. Sorry. On that note, Tuan Nguyen, a manager of customer service in TDLR since 2014, has been promoted. He is the new customer service director. He officially started his role on August 16th. So welcome, Director Tuan, as I like to call him, and we wish the best to Director Trey, former Director Trey. Other personnel updates. Customer service quality training and performance analyst Stephen Nguyen has accepted a position with TDLR's Office of Process and Project Management, OPPM. Because of his impressive commitment to developing onboarding training as the agency grew with more and more programs, and because of his dedication in helping develop a more sophisticated and detailed report, he has seen those efforts awarded with his new position. We're excited to see the value he will add to the OPPM team's projects. Customer service is currently hiring for a new quality training and and performance analyst and 8 customer service representative positions. So it's a very integral part of the agency, moving and shaking, and we're looking for more good people. The next page that we have are statistics. As we can see by the graph, we have some lows and some upticks. We have fiscal year 2020, and then we have fiscal year 2021 through June. And we can see the numbers there for emails and calls and the number. And I'm going to tell you, since this isn't my regular report and I don't work in customer service, if you have any questions, I will take those questions back to that staff and we can get those answered for you. I'm just pinch hitting today. Director Tuan is training his team and they had something special today and they couldn't be pulled away from it. So I said, sure, I'll give that report for you.
All right. Well, thank you very much.
Thank you.
It seems to reflect our experience as well from a business perspective of 20 and 21, where things were quite interesting and then began to pick up. So interesting for sure. Wanting to move on to the enforcement division, Mr. Chris Funderburg with a report, please.
Excuse me. Yes. Thank you. Chairman, Commissioners, my name is Chris Funderburg, and I'll present enforcement's report to you today. To start, I'd like to go over some personnel updates and recognize several prosecutors who have just joined the department. After that, I'll go over some key statistics that summarize the past 2 fiscal years of enforcement action within your profession and how those actions fit into our overall regulatory efforts. Finally, I'll review the 2 hearing instrument fitters and dispensers case that enforcement pursued a disciplinary action, in this case, to a license revocation in both. Now, before we dive into the statistics that start on page 1, you might be able to see that almost all of them are derived from enforcement's case resolution process. So if you're unfamiliar with it, I'd just like to provide a little context on what these terms are referring to. So the case resolution process starts when someone files a complaint with the department. This complaint could be filed by a private citizen, an outside agency, law enforcement, or it could be an in-house complaint filed by a TDLR division. And if this complaint alleges a potential violation of the rules and laws we administer, we open a case to find out what happened. Now, at this point, the cases fall into one of 2 classes, and it's based on the person who filed it. If the department reviewed a licensed applicant's criminal history and filed a complaint based on that result, then the case is assigned to our criminal history team. If anybody else filed it, it's a program case, and it's assigned to the attorneys working that program. Other than this distinction, criminal history and program cases are very similar and share the same pool of possible final resolutions, which you can see at the starting on page 2. These resolutions fall into one of 2 broad types. If a case is closed after a review and adoption, either by TDLR's commission or review and adoption by our executive director, it's considered formally resolved. Any case resolved without the review and adoption is informally resolved, which you can see as the final statistic at the bottom of page 2. This distinction, I think, is going to be a little easier when we take a look at the stats themselves. Now, before I begin talking about the numbers, please note that these statistics are derived from the past 2 fiscal years. The first set, statistical year of 2021, is partially incomplete, though it's by necessity to ensure you received our report timely. It starts on September 1st, 2020, and ends June 2021 of this year. The second set, statistical fiscal year 2020, starts on September 1st, 2019, and ends August 31st, 2020. So if you could take a look on the bottom of page 1 at the key statistics, you'll see that we had a carryover of 27 cases from the prior year, and we've opened 10 so far this year, so for a total of 37. But as you can see, we've been able to close more cases than we've opened, and now with 29 cases resolved so far, just 8 remain open. Now, Now, page 2 of the statistics focuses on those aspects of the case resolution process that I was discussing. As you can see, HFD, excuse the acronym, HFD cases are mostly consumer-based complaints, with roughly a quarter based on the department's review of the criminal history of applicants. We review applicants when they either apply for a new license or when they apply to renew their license. This 25%, 75% split almost exactly mirrors the overall average of TDLR. Also on this page, you'll see that the number of HFD cases resolved within 6 months is slightly lower than the global average. I think this is likely due to the frequently technically complex allegations in this profession, and also the need for expert advice to assess an allegation's viability. On the same page, under the header Case Outcomes, you'll see that some of the terms I mentioned earlier, commission orders, default orders, agreed orders, these are all cases that require the review and adoption by our ED or by our commission. There are no such cases so far this year, though, and that means no penalties were assessed, no sanctions were imposed, etc. The remainder of some of the statistics that you're looking at. Instead, all 29 cases were resolved informally. For example, an informal resolution might be where the evidence doesn't support the allegation, and so we close the case, or if the violation alleged is outside of our jurisdiction to regulate. At the top of page 3 is a list of violations most frequently alleged in the HFD-based complaints. There's a big difference between this list, with late, incorrect, or no refund, false, misleading, deceptive advertising, the most frequent, and compared to the list of violations alleged that actually resulted in disciplinary action, which is 0. As you can see, the requirement of evidence makes quite a difference. The second set of statistics from fiscal year 2020 mirrors what you saw in 2021. And during my review, I didn't see any outliers going one way or another that needed your attention. That said, the 2 cases I'll discuss next were resolved in 2020. They're the case outcome on page 4. They're categorized as the license denied, revoked, criminal history, and they're also on the next pages as the 2 cases that resulted in disciplinary action. That is the criminal history cases. Now, with that out of the way, finally, I can turn to these cases. The procedural history, yes, thank you. But the procedural history of them is the same as the respondents are father and son, respectively. Both were involved in a sustained program to fraud Medicaid of $27 million based on fraudulent claims they'd file for hearing aids from on behalf of clients who neither wanted or needed these devices. Now, the law, one of the occupational codes that govern TDLR's enforcement procedures holds that upon imprisonment for a felony conviction, the license holder's license is revoked automatically. This is going by revocation by law, meaning that we don't even have to a contested case isn't necessary for the revocation to take place. Rather, it just stops existing on the day that they're imprisoned. So on that date, which was August 16th, 2019, both respondents' licenses were effectively revoked. We sent a letter to them on January 24th, 2021, advising them of this. And but as of the date of their conviction, their license ceased to exist. While they can apply for a new license once the revocation period is over in 1 year following the date of their imprisonment, they will have to reapply for a brand new license as their formerly existing license has been revoked and extinguished. That's all I have for you today. If we have any questions, I'd be happy to try to answer them.
Will there be any questions? What? Mr. Davila, I saw you look up.
Yes, I have a question. Is the date of revocation August 16th, 2019?
I see there is a typo. Yeah, yes, it was the date of their actual imprisonment. You're correct.
Okay, got it.
Yes. Yeah, they're 2016. I apologize. Yes, no, that was the date of their. So they are actually, if they're out of prison, which they're not. I think the father went in for 8 years and the son 6 or son 7. When they get out of prison, they can reapply. However, their reapplication process is going to be colored by their imprisonment, and so we may not grant them a license even though they apply for a new one.
Very good. Any other questions? Well, thank you, sir. I just, having had an opportunity to be around folks that have been directly involved with some of the enforcement type situations, I just want to say thank you to TDLR for being very efficient and effective, and obviously some very impressive statistics in getting things addressed on behalf of the public and for the licensees. So thank you very much.
Thank you.
I want to move on to the Education and Examination Division and call on Mr. Michael Strawn to give his report, please.
Good morning, Chairman and members. Michael Strawn, Education and Examination Division, the manager for one of our sections. And I will be giving you our statistics for our examinations today. Our practical examinations for fiscal year 2021 are coming to a close, and they are very similar to what we've seen in past years. We have 101 people that have passed, consistent with last year, 121 total examinations that were administered. Going down and looking at our past statistics, we very much are in line with what we've seen in the past, with the practical ear impression being slightly up in the pass rates. We did have in January, the practical audiometric was slightly lower than we've seen, but it was a very small sample size of individuals that came in for that month during that testing. So, 1 or 2 additional failures can swing that percentage on the pass rate drastically. heading down to continuing education, we have 4 renewals that we have issued for our providers, maintain consistent with our number of providers, and then, sorry. Our provider renewal licenses, again, are staying consistent. We, maintained 15 throughout the year, ended up with that as a total, and our total course count is 448 for the year. With that being said, that concludes my report, and I'm open to any questions that you might have. I'm sorry, we do have jurisprudence exams. I apologize. We had 46 total jurisprudence exams administered for fiscal year 2021, and fiscal year 2020 it was 43. So again, all of our statistics remain very consistent from year to year in this program. Thank you.
Any questions from anyone? I had a couple of quick questions, if I may, that I've heard from different folks. And one of the questions I have is, I'm curious the statistics where someone has passed the practical exam, but has not passed the written exam. And I'm curious, do you have statistics to show if they pass the practical, how many times it takes them to pass the written? Do you have any data like that?
I do not have any data over the written examinations. We could always look to see if we could pull first time pass statistics for the practical examination that is administered by TDLR, though.
Right. I think the question that's coming up from some people is that their folks pass the practical and therefore are deemed somewhat competent in those areas, but yet take multiple times to pass the exam. And so I was just curious if we had any data that we could take back to those people that are asking that question.
I can always look to get with everyone, see if there's any data that is able to be obtained by TDLR to pull back for you all. And if so, provide that to you all. I will not be able to get that today. I do not believe, though.
Certainly, understandable. Another quick question, if I may, and one of the things that people have expressed to me as concerns is there's perception that if they fail a portion or fail the exam, they're not told what sections they fail in order to prepare better to pass the next time. Do you have any data on that?
They should be getting a score report that comes from from the practical examination. I apologize, I don't know exactly what the score report looks like for hearing fitters, but I can pull an example of that to provide you all. They are able to write comments in, not for practical, but for written exams that we administer at TDLR, we have an opportunity for candidates to write in comments. For the written exam, TDLR does not administer that. For the practical, they should be getting scored on everything. But again, I don't know exactly what that breakdown looks like. We would have to get with IHS on that.
But if that would be a possibility, it would seem to be some good information. And I know as we've helped some people become licensed over the years as well, and it certainly would seem beneficial for people to be able to do a targeted retraining in order to make sure that they're effectively prepared. So any information would be greatly appreciated to try to help in people either understanding it's appropriate or in asking further questions. So I would appreciate that.
Yes, sir, Mr. Brooks. We'll look at pulling that information and see what we can get you.
Thank you very much. Any other questions for Mr. Strawn? Thank you very much for all your efforts. Thank you very much. Let's move on to the Regulatory Program Management Division, Ms. Katie Bryce.
Thank you. I am Katie Bryce with Regulatory Program Management in the Medical and Health Professions section. We have 2 new staff members, Angela Sanders and Sean O'Neill, joined our section in February. They previously worked for TDLR, so they just transferred to our section, and they have been a nice addition to our team. Under current projects, the TDLR Health Occupations Annual Report was submitted to the chairs of the House Licensing and Administrative Procedures Committee, House Public Health Committee, Senate Business and Commerce Committee, and Senate Health and Human Services Committee in February. The report is statutorily required and was emailed to advisory board members earlier in February. It's also available on the TDLR webpage. Staff have been working on rule review projects for 6 of the medical and health professions programs. These are the rule reviews that are required every 4 years. We've also been working on bill implementation teams to implement statutory changes from the 87th regular legislative session. One of those teams is for Senate Bill 40, which is related to telehealth, which this program has been working on also with the emergency rules and the telehealth rules we'll see today. Staff have been assisting our Office of General Counsel with emergency draft rules related to the emergency waivers, which were granted by the Office of the Governor last April. We've also been involved in the development of a new Texas licensing system, which will replace our Versa online system in the future. We have some staff members, Steve Eaker and Stuart Myrick, who are working with the Texas Division of Emergency Management's State Operations Center as TDLR liaisons. They are keeping us all up to date on changes with COVID and DSH's response to that. For outreach, our outreach has been limited due to conference cancellations, but we are looking forward to the Texas Hearing Aid Association convention in June of 2022. It's already on our calendars, and looking forward to getting to be back out and seeing our licensees in person. And that concludes my report.
Thank you. Certainly think it is tremendous that TDLR has a presence at the conventions and allows people to be approached and ask questions. So thank you very much for that. Then are there any questions for Ms. Bryce? Then let's move on to the executive office. Mr. Mike Addis-Mendez, would you have a report, sir?
Presiding Officer Brooks, board members, this is Mike Addis-Mendez. I'm the Deputy Executive Director for the Texas Department of Licensing and Regulation. I hope you can hear me fine. My apologies, I was having some technical difficulties, so when I'm now in a conference room, I had to kind of switch over, so I hope you can hear me just fine. Just so you know, this has been a busy session for us. It was a unique session because of the fact that we had a lot of COVID protocols in place. But one thing about is the legislative session and bill implementation teams. We were tracking just a little over 300 bills out of legislative session. The biggest one that we want to talk about is HB 1560, which was our sunset bill. And the most positive thing that came out of that is that we were extended for another 12 years. And so we will now go back under sunset in about 12 years. It'll be 2033. But that's a good thing for us. It allows us to be able to continue our programs and with the various different industries that we're involved in. There was some deregulation of licenses that took place. Nothing that's affected the hearing instrument fitters, nothing in your industry. But we did have some, such as in our combative sports division, cosmetology, barber, those particular industries. There were some licenses that were deregulated there. I can tell you that our legislative appropriation request was approved. I'm not sure if you remember, but a lot of we received a 5% reduction that took place last summer, and they carried that forward into the biennium that we're currently in, starting September 1. So we saw a 5% reduction, but we managed to be able to absorb it and are moving forward and not having anything hit the various industries or programs that we currently license and regulate. Another big thing that happened to us was that we received some additional funding for the Texas licensing system, which I believe you've heard earlier, some individuals talking about. We received additional funding to complete that project, so we're well on our way to try to get that completed so we can have a brand new licensing system that would encompass all of our programs and all of the licenses that we currently have. So we're looking forward to having that completion. We're still years away from getting it completed, but at least we know we do have the funding for it, so we're looking forward to that. I can tell you that when the legislature is in progress, that's kind of a break for us. Our work actually begins when the legislative session ends. And so when the legislative session ended, then our work began. And so a process of doing that is implementing all of the changes that took place to the process and legislation that was filed. So we are now in the bid implementation team process. So we have over 20 teams that have been organized from various different divisions throughout the agency, which includes, of course, RPM, licensing, enforcement, E&E. We have financial services. We have our OPM group involved, our IT division. So it's just everybody involved, hands-on, to make sure that everyone's understanding and we're implementing the bill that was passed to ensure that we're properly locating and doing everything we need to within the agency that it would hit and identifying that. So we're currently going through the rules, which would be changes made through our general counsel's office. And we're making sure that what we're going to do is interact with every agency and every industry that these bills affect to make sure we're getting feedback from them on how they believe is the best way to implement that process. So, you know, it's a long, drawn-out process for it, but we want to make sure that we're implementing it correctly. We want to make sure that we're implementing it in a manner that is least impactful to the industry based on any change that had to be made. But I think it's still a process by which we're able to get a lot of success out of. So I'm available for any questions if you need to, and I'll be more than happy to answer.
Any questions from anyone?
Board members, thank you.
Thank you. Thank you to TDLR. We appreciate your efforts and assisting and taking time out to visit with us today. If there's no questions or comments, then I'd like to move on to item number G.
Presiding officer, we do have Mary Winston, TDLR. We do have one little bitty section from 6 that we want to go over. It's the communication outreach statistics.
Please
That
proceed.
just gives
Sorry, I missed
us
that.
Oh, I'll say no problem. Mike was being so thorough, and he looked so official in that room by himself there. But thanks for being able to overcome those technical difficulties, everyone. Over the past 6 months, from February 15th to August 15th, the Hearing Instrument Fitters and Dispensers website has had approximately 18,000 views, about 101 per day. 63% assess this website from the desktop computer, 36% from a smartphone, 1% from a tablet. As you know, this changes depending on which program, if it's more readily accessible via laptop or a desktop. Tablets are still not a major form of reaching out that we can see at this time. This helps us to distinguish what information we're disseminating, how it's being received, and what are the 5 top reasons or more that the page is being accessed. Number 1, how to apply for a hearing instrument fitter and dispenser license. Number 2, examination information. 3, forms and applications. 4, temporary training permits. And 5, how to apply for an apprentice permit. Again, this is the top 5 this time. We assess this daily, actually, and we get something quarterly to let us know how our pages are doing, what other information needs to be sort of put on the forefront. And we have our webmasters place that where they know it should be placed to be readily accessible for the public and the licensee as well. And if you have any questions, I'm here to answer them. If not, Presiding Officer Brooks, we're ready to move on to the next topic.
Any questions? All right, very good. Thank you. So again, want to move on then to item G, discussion and possible recommendation on the proposed amendments to existing rules, the proposed new rules, and the proposed repeal. Quite a bit of material to look at there. Would call on Ms. Wendy Pello to present us with that information, please.
Thank you, Chairman. Again, Wendy Pello, Senior Assistant General Counsel. I'm going to share my screen with you all. You have the rules in your packet. I'll put these up on the screen. We have Any changes or comments? Hopefully y'all can see that. Um, as the chairman said, this is where the telehealth rules, and we are amending the existing rule 112.2, adding two new rules, 112.130 and .132, and then repealing the existing rule 112.150. Before I get into the specific rule changes, I want to just kind of give you a little overview. These proposed rules that are in front of you, kind of, there's like four categories of changes kind of up here in the prints. The first is the emergency rules. When the advisory board met a few weeks ago on August 6th, we brought standalone emergency rules to you that were implementing the waivers that had been granted by the governor during COVID-19 pandemic. This advisory board had recommended to the commission that those emergency rules be adopted. The commission met on August 10th, and they adopted the emergency rules. And those emergency rules will go into effect on September 1st, 2021. It's important to just as a reminder, those emergency rules are only good for effective for 120 days. There's the option of a 60-day extension for a total of 180 days. So what the proposed rules in front of you today are adopting or implementing those emergency rules on a permanent basis. The next category of changes that are in these rules is implementing Senate Bill 40. As Katie Bryce had mentioned in her staff report about Senate Bill 40, it's the telehealth bill that impacts TLR's health-related programs. Made changes to Occupations Code Chapter 51, which is the department and the commission's enabling statute, and added a telehealth section into those rules. And so this bill is implementing those telehealth changes. One of the other changes that was in Senate Bill 40, in addition to adding telehealth provisions and new rulemaking authority, was it repealed the joint rules for the fitting and dispensing of hearing instruments for this profession and for the speech language pathologist and audiologist profession. So these proposed rules today are implementing those two elements of the telehealth and then the repeal of the joint rules. The next category is rule review. And I kind of mentioned this earlier in the training is with rule review. The Chapter 112 rules for your profession underwent the 4-year rule review. Notice was published in October, and then the rules were readopted in their entirety in their current form back in March. As in response to the notice of intent that we published in the Texas Register and put it on our website and sent out through our GovDeliver email system, we received 2 public comments in response to that notice of intent. One of the comments, they had recommended 4 rules, amendments to 4 rules, and one of those rules was the joint rules for the fitting and dispensing of hearing instruments by telepractice. That comment was suggesting changes in the terminology and definition of hearing instruments. The department did not incorporate those changes. Those are the definitions that are in the statute and earlier on in the rules under 112.2, but these rules do incorporate the department's review through the rule review process as they relate to telehealth. So we do have kind of the department's take on that. And then the fourth category is kind of reorganization, and we've created a new subchapter for the telehealth rules and have relocated and reorganized the existing provisions along with new provisions kind of by subject matter. So that's kind of like the overview is getting into that. So if there's any questions as we move along, please feel free to jump in. I'll be scrolling through the rules, but open for questions. The first change we have is in 112.2 in the definitions. And what we have done is just add a simple definition of telehealth and just a cross-reference of see the definitions in the new subchapter in telehealth. And so this is because there's a whole new section, our whole new subchapter has its own section of definitions. We've just put this here as a helpful reminder that there's definitions related to health elsewhere. Under subchapter N, this is a new subchapter, and it has 2 new sections. As you look through here, I've annotated the draft, and so it's annotating where we have discussion points. I mean, this is all up for discussion, but there's certain things we definitely wanted to get input on, but it's also annotated of where the the current rule is where it's being relocated, because now it's all showing up as new subchapter, new section. So we want to let you know where it's the rules come from, or if it's a new rule. These current rule with the definitions related to telehealth, these were being relocated from 112.150B, the joint rules, as necessary and with some modifications. There's other definitions again in 112.2. So for this section, because it's all showing up new, but just kind of, we've made some cleanup changes to client site, facilitator, provider site. We have added a definition of in-person, and this is relevant as it relates to having the same quality of services and standard of care being in person, being delivered through telehealth as in person. So important to have just a definition of in person. So we've added the definition in person there. One of the definitions, and we definitely wanted to talk about, was provider. And in this draft, provider was including all three licenses and permits: the hearing instrument fitter and dispenser license, the apprentice permit, and the temporary training permit. And the discussion we wanted to have is, right now under the joint rules for fitting and dispensing of hearing aids through telepractice, for this profession, the only license or permit type that was able to be considered a provider was the full licensee, was the hearing instrument fitter and dispenser license holder. And so our discussion, we wanted to discuss with the advisory board is, do you want the definition of provider to be expanded to include apprentice permit holders and temporary training permit holders who have completed the direct supervision training requirements to allow these people to provide telehealth services?
Richard Davila, I feel like apprentice permit holders, properly supervised, as well as temporary training permit holders that meet the criteria for supervision should be included.
Appreciate that feedback. Any other comments or thoughts on that? And when I get to them later, we've put some protections or some, provisions in there about needing to be supervised and what they're able to do. So that's the draft. And that's, like I said, the waivers and the emergency rules didn't include the apprentice permit holder and temporary trainers, but this was something we wanted to have a discussion as we had a more comprehensive telehealth bill.
Richard Davila, apprentice permit holders are, have an entire year where they're working indirectly. So, not direct supervision. It is a long period of time between passing your, moving from temporary training permit to full licensure, and, effectively have passed both exams. You're meeting the criteria, having a 1-year apprenticeship, with basically all you have to do is get some continuing education, a little more than normal. And then you move in, it's a time period, move into full licensure. And, specifically those, the criteria to meet for supervision for apprentice would be really easy to make. Temporary training permit holders, you'd actually have to have, a supervisor and a temporary training permit holder, at least for this first 160 hours, right next to each other. But in order to function with telepractice for an apprentice for an entire year, they'd be left out. And I think that would be disappointing.
So you're saying the verbiage is good as written? Is that what you're supporting that? Is that correct?
Richard Davila, no, we're leaving out apprentice permit holders, only allowing fully licensed people, as it's written.
Oh, I'm sorry. I'm looking at number 5 there. This after the semicolon. I was sorry, Wendy.
No, that's right. As it's written, as in this new draft, it includes all three. It includes the full license holder, it includes the apprentice permit holder, and it includes the temporary training permit holder who has completed the direct supervision training requirements.
Yeah, I'm sorry about that.
No, that's right. Under the current rules, it's only the hearing instrument fitter and dispenser over in 150. So that's expanding.
But it's an excellent argument. So we're agreeing then with the verbiage? Excellent. Thanks.
Right. Telecommunications technology, this was included in the waivers in the emergency rooms, emergency rules, excuse me, about the use of smartphones, the clarification about the analog telephone, email, and fax, similarly not being telecommunications technology for purposes of this definition, just expanding that definition of telecommunications technology. We have updated the definitions of telehealth and telehealth services. The former rules under 112.150 referred to these as telepractice, and that was changed in the emergency rules, but we've also updated those definitions. That's use of telecommunications information technology for exchange of information from one site to another, provision of service to a client from a provider, including assessments, interventions, or consultations regarding client or for the fitting and dispensing of hearing instruments. And then we've added, telehealth is also referred to as health practices. There's that kind of shift in maybe terminology. People just letting folks know that this is what we're talking about. We're talking about the same thing.
This is Lance Brooks. Just
Sure.
one of the words that I keep seeing people try to find a way to put in there is synchronous. That you've got synchronous communication going on, both oral and in video. And it seems like you're capturing it there, but the word that I kept looking for was synchronous. That's the word I see associated around that for whatever value that would bring.
That's what I was looking. Concurrent, two-way. Okay. Were you having a suggestion of where you would like that?
It would have been good if I had done that. I know as I was reading the rules again, read them earlier, and then I read them again this morning, and I thought, the only word I saw missing was synchronous. And to me, you've tried to capture that by saying smartphones and equipment, but again, that seems to be the buzzword that I see different forums using.
Richard Davila, just to clarify the definition, existing or occurring at the same time, synchronous, just the definition for those of us that may not know it.
So I'm trying to think where would be
Just
the
to
best place.
Yeah, so if you scroll up a little bit in the telecommunications section right there. Right there. Interactive communication at a distance by synchronous two-way transmission would probably take care of that. I mean, concurrent has an incredibly similar meaning, but I think that's the spot where we would insert that
That's
word.
where you'd want the synchronous.
Richard Davila, I would say concurrent and synchronous, both meet the definition of occurring at the same time.
Right.
Fair enough.
Oops. I'll have to double check the spelling on that, but I'll get that in there.
I've got it. It's CHRO SYNCHRO NOUS.
Thank you.
Wendy, this is Katie Bryce, and I wanted to mention that the word synchronous is in Chapter 111, which are the overriding kind of telehealth statute, and so it is covered in that. Not that it hurts to have it here too, but just so you know, it is there.
Thank you. Just going to flag that as a new addition. Okay. Thank you. I appreciate that feedback. So that helps clear that up. On any other suggestions on that, on the communications, the telehealth, the teleservices? Thank you. Those are the definitions. Moving to the next section. This is the new section 112.132, requirements for providing teleservices and using telehealth. We have reorganized this, kind of taken most of the subsections that for 112.150, I think it's subsection C through N, we brought most of those provisions over and reorganize those provisions kind of by subject matter. We've also added some new rules, borrowed some rules that the speech language pathologists and audiologists have in terms of kind of building out a full kind of telehealth rule and kind of addressing the different issues in that. For applicability, this section then would apply, the subchapter, excuse me, would apply to the hearing aids, fitters and dispensers, apprentice permit holders, and temporary training permit holders as authorized in the subchapter based on our early discussion about provider. Again, this doesn't affect, the subchapter doesn't affect the applicability of any other requirements or of laws that the individual has to comply with. That's from the current, what I'm calling the joint rules. Licensure and scope of practice. An individual cannot provide teleservices to a client who's in Texas unless the individual holds a license or permit issued by the department and qualifies as a provider, as that term is defined. And the provider may only provide teleservices that are in the scope, course and scope of their license and permit and their competence and delivered in accordance with the requirements of this. One of the things that Senate Bill 40 and added that to into the new section in our occupation code chapter 51 is the use of telehealth does not change the scope of practice. It doesn't authorize you to do anything that would be outside of your normal scope of practice if you're doing it in person. It doesn't expand what the services that you could, or what you're authorized to do. Here's where we've added some provisions as it relates scope of practice as it relates to the apprentice permit holder. Again, the apprentice permit holder may provide services under their supervised license and then according to the supervision requirements that are under 112.43. There's already existing rules about supervision requirements related to apprentice permit holders, and those would still apply in the case of telehealth. And then for temporary training permit holders, they can provide telehealth service as directed by their supervisor and according to those supervision requirements. There's a lot of supervision requirements in the statute under subchapter F, and then there's also supervision requirements under the rules 112.53. And this provision is saying it's the provider who's a temporary training permit holder may only provide teleservices after they've completed that direct supervision training requirements. Any questions, comments? Let's keep rolling on. We've got a section on competence and standard of practice. You have to be competent about the type of services and the methodology and equipment being used, comply with the code of ethics and scope of practice requirements. This is important. The scope, nature, and quality of the services that are being provided via telehealth have to be the same as the service provided in person. And then this has been implicit, but we've added a new rule here in terms of you have to determine whether the service or procedure is appropriate to be provided via telehealth. And the provider shall not provide the service or procedure by telehealth if it's not appropriate or can't be provided at the same standard of care as if it were provided in person. And then same with liability malpractice, that's being held to the same standard. Facilitators, a lot of these have been moved over from the current joint rules. Authorized to use a facilitator at the client site to assist in providing telehealth services. The provider needs to document whether they're using facilitator, and if they do, what tasks the facilitator is providing assistance. Before allowing the facilitator to assist, this is one of the changes that was made through the emergency rules, is the provider kind of ascertaining or documenting their qualifications, training, and competence kind of as appropriate and reasonable, the tasks they're performing, and then the method and technology. And so this is trying to kind of broaden the use of facilitators a little bit. These were the provisions they can provide. It's either a task that they have the license or permit that's required. They hold that license in order to perform that particular task, or it's a physical, administrative, other type of task, which the facilitator is determined to be competent to perform. This used to be that the provider had provided training to the facilitator. So this is a kind of a determination of competence, whether they can assist in providing services. And these would be services or tasks, excuse me, that don't require a license permit. And then the provider is responsible for the actions of the facilitator, needs to monitor the client and oversee the facilitator at all times. And the provider shall not provide teleservices to a client if the presence of a facilitator is required, but there's not, in order to provide the services effectively and safely, but there's no qualified facilitator available. We also have a new subsection on technology and equipment, using only the telecommunications technology as we defined earlier. Things like analog phone, fax, and email, they can use it as adjuncts, but those are not telecommunications technology as defined. And they should only, the provider should only use technology and equipment that they're competent to use, provide and only provide teleservices unless the communications technology equipment at both the client site and the provider site are appropriate for the services to be provided, are properly calibrated. There may be certain equipment, audiometers, other things that need to be properly calibrated, but are in good working order, and that are of sufficient quality to allow the provider to deliver equivalent services and quality through telehealth that they would have provided if they're in person. We have a section on client contacts and communications. And this is, again, we had addressed this first paragraphs 1 and 2 in the emergency rules about the initial contact between the provider and the client being at the same physical location or telehealth as determined appropriate by the provider. And the provider, considering certain factors regarding the client, whether it's appropriate to provide services via telehealth, be aware of the client's level of comfort with the technology, be sensitive to any variables that may affect delivery, identification, assessment, treatment of the clients via telehealth. And then this fifth is would be new for you all, but it's from the speech language pathologist. It's notification of telehealth services being provided to the client, guardian, caregiver, multidisciplinary team if that's appropriate. But it's letting the client know, and that notice needs to include but not be limited to the right to refuse telehealth services and what their options are for service delivery, and then any instructions on filing, resolving complaints. So telehealth is an option, but it's not a requirement that the provider delivers services that way, and it's also same from the client's perspective in terms of if they're comfortable receiving services that way. And then records and billing, this is these first two are carried over from the joint rules about complying with all laws, rules, regulations regarding client records, including client confidentiality, documentation of the telehealth services, date and nature of the services, any use of facilitators. And then this third one is a new one in terms of while you're licensed and you're authorized and you're licensed to provide telehealth services, that's a separate issue from the reimbursement issues. And so whether insurance or Medicaid or whatever, or whoever the payer would be, whether they would allow, provide reimbursement, provide reimbursement for services provided via telehealth, that's a separate issue. So this is kind of a notice to the providers about that. And then with hearing instruments, hearings may be adjusted digitally through the use of telecommunications technology by a provider under the subchapter. And one of the questions here, we have providers. So this would be all three, be the full license holder, hearing instrument fitter, dispenser, the apprentice permit holder, and the temporary training permit holder. So one of the questions here is, should all three be in this provider, or does this need to be separated out? Or all three authorized to digitally adjust?
Richard Davila, I think all three should be
Okay.
be able to adjust if they meet the criteria of supervision.
Okay. Okay. Yeah, because that's a provider, so that's as defined. That's all three. So just want to double check. And then the other changes, this is what's showing is where the joint rules, the current joint rules for fitting, dispensing hearings by telepractice, and this is being repealed in its entirety. And the statutory requirements for these particular rules were repealed by Senate Bill 40. Like I said, the necessary definitions have been moved up to 112.130, or they're already in 112.2 at the very beginning of the chapter. And then again, most of these provisions have been relocated to 112.132. So any questions or comments, discussion? You don't have any discussion, we would be currently looking for a recommendation to publish the proposed rules on the Texas Register, open that for public comment with the change that was made earlier about the change to the telecommunications technology.
Richard Davila, is this, are we make this motion, does this include comments on the 2 public comments that were made, or is that for item H?
That's for item H. That'll be
Okay,
for
then, yeah, then I would like to move that that we accept the draft proposed rules for telehealth with the one change that we made to 7 under telecommunications.
Thank you, Mr. Davila. Is there a second?
I would second.
Thank you, Thank you, Mr. Potter. And is there any discussion? Then would Ms. Lopez Sparks please poll the group, please?
Yes, and this is Delia Luna, and I am going to poll the board for now. Richard Davila,
I think you were muted.
Mr. Davila,
Unmute. Okay, my bad. Aye. Sorry.
Gary Hahn,
Aye.
Amy Trost,
Aye.
Deetra Stewart,
Aye.
Dustin Potter,
Aye.
and Lance Brooks, presiding officer.
Aye.
Motion passes.
Thank you.
Thank you all.
So moving on to item H, thinking about those late inning stretches. Thanks everyone for an hour and 18 minutes in here. Ms. Pello was going to bring us an update on the 4-year rule review of the rules of the 16 TAC Chapter 112 hearing instrument fitters and dispensers and possible next steps. Ms. Pello.
Great. Thank you very much. Share my screen here with you again. Yeah, just as I've mentioned, this 4-year rule has kind of touched a couple of agenda items here in terms of the training and then the previous agenda item. For the 4-year rule review, I said is we've got 2 public comments. One of the comments had comments on 4 different rule sections. Like I said, we addressed that one particular rule section in the joint rules in the previous agenda item that wasn't being changed because that was the current definition in the statute rules. But we still had one of the comments was not recommended readoption of the rules without changes, and then the other comment that had the 4 pieces or the comments on the 4 different rules, there's still those sections there to discuss. And so we wanted to bring you an update. We've have those changes, and where we are in the process is those rules have been readopted by the commission, but now we take a look at those public comments and get possibly send those to work groups and talk with the staff about those issues and whether there needs to be future rulemaking based on those comments that we submitted that were submitted. And so let's see, in your materials we had included the Texas Register adoption notice. Share them. The adopted rule reviews, and this was part of a the chapter 112 was part of a multiple chapters that were undergoing review at that time. And so for the hearing instrument fitters and dispensers, this was the blurb, and this was in the Texas Register. This is also on our website, and it was also in our GovDelivery emails. But let's see if I can increase this a little bit. But the issues that were still left outstanding were the issues related to audiometric testing, continuing education provider fees, and the sale of hearing instruments. And those were the rules under 112.140. Those are the joint rules that that this profession has with the speech language pathologist and audiologist. So what we were would like to propose as for the advisory board is to possibly delegate those remaining comments out to standing work groups, or if you want a new work group, and have those discussions with staff of whether any further action needs to be taken on those changes. And again, we've got public comments, but we also have the department's review as those rule reviews. So that can be part of the discussion.
Any comments, any questions?
I have a
Mr.
comment. I
Douglas?
mean, are we referring these to work groups, or are we having the discussion on these remaining? One was no rule adjustment. I guess there's 3 remaining comments. Is it your prerogative, Mr. Chairman, to divvy these 3 issues into work groups and then have them bring back to the advisory board, I guess with TDLR's help, a recommendation, or to have some type of, polling or discussion here on those comments?
Well, certainly my preference would be to ask the staff to reach out to the existing work groups to include that, but I wanted to ensure if there was a particular question or comment, as long as we don't get into the weeds that we're not allowed to discuss in this meeting, wanted to make sure there wasn't an additional comment.
Well, I think now's the time to discuss it if we're gonna discuss it and it not go to work groups, but are you thinking work groups?
Well, I was just thinking that would allow them to work with the appropriate staff and to bring back a recommendation to this committee or board. And so that would be my recommendation. Yes, sir.
Are you appointing new work groups today, or do we need to? We've got some new members and I'm not sure what the boards
Right.
look like or work groups look like.
Item number, yes, sir. Item
Okay.
number K will be looking at filling the opening that was vacated by Mr. Norris. And there are 6 work groups currently, or 5, I guess, and we'll be discussing that when we get down to item number K.
Mary
And then,
Winston, TDLR.
and then appropriately putting these topics in those work groups.
Yes, Mr.
Got
Davila. I'm
it.
sorry, I'm stepping in. Mary Winston,
That's all
TDLR.
right.
Wendy, I know you kind of presented this and those next steps as she's talked about what this goes into. Can you kind of provide a little direction? And we're almost there, we're getting there, but wanted to make sure Wendy, as the Assistant General Counsel for this, could kind of lead us through.
Right. I think our recommendation to the advisory board, it was to go ahead and send these to the work groups, and they can kind of have a fuller discussion of the issues that are there. There's some, there's a lot of materials, there's a lot of pages, some issues to dive through, so we can send those. I think the nature of the issues and the comments that were raised would fit under existing work groups, that you wouldn't need to have a new work group. Like for audiometric testing, this is an issue that's come up before that could go to the standard of care work group. The continuing education provider fees is a comment that could go to our education examination work group. And then the sale of hearing instruments, this is related to, like I said, to Rule 112.140, the joint rules for the sale of hearing instruments. So we have a joint rules work group, so that could go to. And again, this last one, the fitting dispensing, has already been handled by staff in terms of with the last agenda item, and that change was not made. So you have work groups that these could naturally go to, so you would not need to appoint a new work group.
And actually, Mary Winston, TDLR, with that said, thank you, Wendy, for that guidance. That presiding officer kind of sums up, and Mr. Davila, this agenda item. And as you said earlier, Mr. Brooks, presiding officer, that in K, you'll be doing those assignments. So with that said, thank you, Wendy, for providing those next steps. If it pleases Mr. Brooks, we can move on to I, and then we will come back around to get those work groups repopulated as necessary.
Very good. Thank you. Then let's move on to I then. We have Miss Amy Trost. Hopefully she is still with us to bring the report from Education Examination Work Group regarding the continuing education related to the human trafficking prevention training as well as updating the format and substance of the jurisprudence test. Amy, are you available to do that, please, ma'am?
I am available.
Thank you.
The Education and Examination Work Group met on July 23rd, 2020 to determine whether the human trafficking prevention training required by HB 2059 86 regular session for each license renewal should count toward the continuing education requirements for license renewal. The work group also discussed the need to update both the content and the format of the current jurisprudence text. Attendees were internal Ray Pizarro, Michael Strawn, Doris Rodriguez, Alisa Cisneros, Angela Schmidt, Rebecca Armas, Brian Bill, Haley Potter, Katie Bryce, Mary Hoffman, Wendy Pello, and external attendees were Ben Norris and myself, Amy Trost. Issues identified: HHSC approves the human trafficking prevention training course and course providers. For hearing instrument fitters and dispensers, continuing education, TDLR approves continuing education course providers. Therefore, a human trafficking prevention training provider would need to obtain approval from both HHSC and from TDLR in order for the course to count toward continuing education and license renewal. Additionally, TAC 112.72G requires the following. G. Each continuing education course will be evaluated by the department on the basis of the following criteria. 1. Relevance of the subject matter to increase or support the development of skills and competence in the fitting and dispensing of hearing instruments or in studies or disciplines related to fitting and dispensing of hearing instruments. 2. Objectives of specific information and skills to be learned. And 3. Subject matter, educational methods, materials, qualifications of instructors and presenters, and facilities utilized, including the frequency and duration of sessions and the adequacy to implement learning objectives. Recommendations. The work group does not recommend accepting the human trafficking prevention training course as continuing education for this program. The content of the human trafficking prevention training course does not meet the parameters in 112.72G, and the work group does not think that the rules should be changed to accept courses with content that isn't specifically targeted to the fitting and dispensing of hearing instruments. The work group recommended keeping the required human trafficking prevention training separate from the continuing education requirements. The work group recommended no changes to the continuing education rules. The issues identified: the jurisprudence test currently functions more like a completion activity than a test. You can choose any answer until you get the right answer and then move on to the next question. TDLR would like to change the format so that if a question is answered incorrectly, you don't get multiple chances to answer the same question. Instead, you move on to another question covering the same subject matter. This continues until you correctly answer a question for that subject. This format would ensure understanding and knowledge of the rules and statutes. The jurisprudence test will also need to be updated to refer to correct rules citations. Our recommendation: members will be responsible for updating the jurisprudence test under direction of TDLR staff. The update will include checking each question, verifying that each question refers to the correct rule or statute citation, updating language as needed, creating new questions as needed, discussing how many questions will be included in the test and how many bank questions will be needed for the new format. The advisory board will be notified when the jurisprudence test is updated, but the test contents will remain confidential to maintain the integrity of the test. And that concludes my report.
Thank you. So really, we appreciate the work of the Education and Examination Work Group in conjunction with the TDLR staff. And if I understood it correctly, the recommendation is that human trafficking prevention training not count towards the 20 hours of continuing ed that's currently required for Texas hearing aid dispensers and fitters in Texas. Is that correct?
Yes.
Okay. Is there a motion that we accept the recommendation of the Education Examination Work Group related to House Bill 2059 related to the human trafficking prevention training not counting towards the 20 hours. Is there a motion to accept that recommendation?
Richard Davila, so moved.
Thank you, Mr. Davila. Is there a second?
Second, Gary Hahn.
Thank you, Mr. Hahn. I apologize. I missed the name. Angelica is no longer on the call, correct? I missed the name of the person that was taking the votes.
I'm here now. Sorry, I had to wait for a second.
Okay, thank you. Would you mind doing a roll call or a
Sure,
vote,
no, I-
please?
Richard
you.
Davila,
Aye.
Gary Hahn,
Aye.
Amy Trost,
Aye.
Deidre Stewart,
Aye.
Dustin Potter,
Aye.
and Lance Brooks, the presiding officer.
Aye.
Motion passes.
Thank you.
Mhm.
The second recommendation of the Education and Examination Work Group was to update the format and substance of the jurisprudence test as Ms. Trost has described, which would, as I understand it, really create more of an examination as opposed to a continuing till you pick the right number. If that's correct, Ms. Trost?
Yes, it is.
So is there a motion that we accept the recommendation of the Examination and Education Work Group regarding the updating of the format and substance of the jurisprudence test?
Richard Davila, so moved.
Thank you, Mr. Davila. Is there a second?
Dustin Potter, second.
I second Teacher Stewart.
I heard Mr. Potter. I wasn't sure who the second voice was.
Teacher Stewart.
And Ms. Stewart also. All right. Angelica, would you mind taking a vote for us now that we have a motion and some seconds?
Richard Davila,
Aye.
Gary Hahn,
Aye.
Amy Trost,
Aye.
Deidre Stewart,
Aye.
Dustin Potter,
Aye.
and Lance Brooks, presiding officer.
Aye.
Motion passes.
Very good. Thank you.
Mhm.
Let's move on to item J, discussion of Senate Bill 40, the 87th Legislature Regular Session, possible assignment of a work group to study the direct, indirect, and remote supervision of permit holders using telecommunication technology. Ms. Pello, would you lead us through that discussion, please?
Sure. This is Wendy Pello of TDLR. This is agenda item. Senate Bill 40 had multiple pieces to that, one of it being telehealth, but it also addressed an issue called telesupervision or remote supervision. This is not something that is addressed for this profession's and your all's rules about telesupervision. And what that means for remote supervision is supervising interns or assistants, permit holders via telecommunications technology. So it's remote supervision. This is in the speech language pathologist and audiologist program. It's not currently here. Senate Bill 40, which you have a copy in your materials, allowed the commission to provide for remote supervision of assistants and other authorized persons performing duties within their existing scope of practice using telecommunications or information technology, and to provide for the remote supervision of experience for apprentices, interns, or other similar trainees using telecommunications or informations technology. So we wanted to bring this to this board in terms of, is this an issue you would like to explore? Is this something you feel would be appropriate for this profession to include those type of provisions? It wouldn't be in the rules we've talked about today. It'd be something for future, but to discuss that and discuss as part of that, discuss direct supervision, indirect supervision as it relates to both apprentice permit holders and temporary training permit holders, and then remote supervision or telesupervision, and whether that would be appropriate for either of those type permit holders. So kind of open that discussion, and then if that's something you're wanting to do, that we could assign it to a work group to kind of get into the details and what that may look like and what rules may look like. So open that as background.
Richard Davila, I feel like that is something that we should discuss and potentially enter into a scope of practice issue. I think maybe would be the work group to discuss how we would be able to do remote supervision. The audiologists have audiology assistants, and apprentice and temporary training permit, when appropriate, could be done. The supervision could be done remotely if it was done correctly. I think it should be studied and rules proposed.
Any other discussion, comments, recommendations?
Dustin Potter. Yeah, I would agree with Richard there. I think there's a lot of cases where that's appropriate, but then there's some cases where it's not. So yeah, we need to have a set of rules outlined for how that would be performed.
Thank you, Mr. Davila. Mr. Potter, any other comments? Very good. Then let's please assign that to the standard of care work group. I think some of the great comments made there about scope and standard of care, very appropriate. And we have an existing standard of care work group. So if that's all right, let's do that. Then let's.
Is it appropriate for me, Richard Davila, is it appropriate for me to ask who's on that? I'm sorry, I'm lost on our work group. So
Sure. For standard of care, we have Carrie Hahn and Amy Trost. We do have one vacant position since Mr. Norris is no longer on the board.
Got it.
Yeah, excellent question. In fact, it was one of the questions I asked as I prepared for the meeting, was to get a list of the groups, the scope, and who was on each group. And if TDLR would allow me, I would like to, when we get to item number K, I would like to be able to just kind of walk through that or read the document that I've been given, if that's okay.
Mm-hmm.
And then I'd like to make a recommendation for the open spots on 2 committees, if that would be all right.
Yes, sir.
All right, so just jumping, thank you. Excellent question. I think we all have, as we try to make sure that we're all doing a good job for the folks of Texas, have some good questions. As I go back to item J, then just to wrap it up, then if would ask if we could send that to the standard of care. And then my understanding is the staff in conjunction with the work group members will review that and then bring a recommendation back to this board. Very good. Thank you. Thank you very much. So let's move to item K. And again, sounds like it's okay if I do that. I'd like to read the document that I have that these ladies were kind enough to provide me with on the work groups, the scope, and who the current membership are. So if it's all right, I'm going to look at that. So the first group is the enforcement work group. And I didn't know if y'all wanted to put this on the screen or if it would be better for me just to read it. Probably just to read it.
Reading it.
Okay. So the general responsibilities of the enforcement work group are review and make recommendations regarding the criminal conviction guidelines, the penalty matrix, and other enforcement related matters and rules. Currently, the members are Mr. Richard Davila, Jackie Cooper, and Lance Brooks. The staff member is Mr. Ron Foster, the Director of Enforcement Division and assigned staff. The licensing work group, general responsibilities are review and make recommendations regarding licensing requirements, inspections and compliance, and other administrative matters and rules. The members are Mr. Richard Davila, Gary Hahn, and Lance Brooks. The staff are Dee Dee McEachern, the Director of Licensing Division and assigned staff. The third group is the Education and Examination Work Group that we heard from today. Their general responsibilities are to review and make recommendations regarding education, examinations, continuing education requirements, and rules. The members are Ms. Amy Tross, Ms. Jackie Cooper, and that is where Mr. Ben Norris had a position that we'll be talking about filling in a moment. The staff are Mr. Ray Pizarro, the Director, Education and Examination Division, and assigned staff. The fourth group is a standard of care work group. Their general responsibilities are review and make recommendation regarding the standard of care and scope of practice matters and rules. Again, reading that definition seemed very appropriate for item J to go there. The members are Mr. Gary Hahn, Ms. Amy Trost, and again, there is an opening where Mr. Norris was. The staff member is Charlotte Melder, the Director, the Regulatory Program Management, RPM. That would be kind of a cool sounding name. We're the RPM group. Division and the assigned staff. The fifth work group is the Joint Rules Work Group. Their general responsibilities are review and make recommendations regarding the joint rules for the sale of hearing instruments with the Speech Language Pathologists and Audiologists Advisory Board. The members are Lance Brooks, Amy Trost, and Gary Hahn. The staff member is Charlotte Melder, the Director, Regulatory Program Management Division, and assigned staff. And as a note, all work groups include rules within their scopes of responsibilities. So certainly gives us some efficiency given the amount of involvement in pulling together an overall board meeting to have these work groups doing some work for us and considering some of the technical and issues that need to be carefully considered in that area that could be considered probably in a little more efficient way and effective way than bringing these things back to the group. So the next point on there, I would like to ask Mr. Dusty Potter to fill the spots left by Mr. Ben Norris. And as such, then we will have 3 members of the board on each work group, and then we can continue on. Sounds like, I know in my experience, I think I've been on the board about 2 years, and there's not been a need for the work groups that I am on to have met, but certainly based on the conversations we've had today, I would assume that as the staff takes these and has a chance to review and as appropriate, that they will be calling up the various work groups to ask for their input as to these matters that have been brought for us today. So that, Mr. Davila, does that effectively address your question, sir?
Yes.
Excellent, excellent. It
I
seems
might,
like
real quick, Mr. Chairman, I might suggest, some point in the future, that advisory board members, the potential, of course, it's your preference, to be assigned to different work groups over time where you're not, only in the work group that you're in. Just as a side note, I think you have the ability to, assign board members to any one of the work groups. And like you said, you weren't involved in any, at least not in the last 2 years, any substantive work with those, work groups. And, each year I might suggest that you revisit the work groups and consider, allowing other advisory board members to serve if you want.
excellent input, and we will take that under advisement. And then if Mr. Potter, if you're willing to accept that assignment, we will have our committees full with 3 members each, and we will move forward with item number K.
You happy to, Mr. Brooks?
Yes, Amy, I'm sorry. Oh, thank you, Dusty. Thank you for accepting that. Amy, I'm sorry.
Could you just repeat the lead staff member for licensing work group?
Amy, Mary Winston here. The staffing person that we have said is the director for each division, right? However, that director typically has a point person that they will have to actually meet with that person. For licensing, Angelica, do you have the actual staff member who's under that director?
I had Leonard assigned to that work group.
That's going to be
Leonard, if I'm wrong, you can tell me.
No, that's correct.
That's
Angelica.
Leonard's still here. So that's going to be Leonard Rivas.
Thank you.
Uh,
Any other questions, comments, concerns? All right, very good. We are rapidly moving forward. Thank you, everyone, we are now an hour 46 in, so thank you for your patience and for your sacrifice and giving your time today. So if we move on to item number L, that is, are there any recommendations for agenda items for the next board meeting?
Chairman, this is Wendy Pello from TDR.
Yes, ma'am.
There will be, when we come back for your next meeting, but we'll have the proposed rules with the public comments that were received, if we receive public comments on those proposed rules that we discussed today under agenda item G. So those will be back before you at your next meeting.
Excellent, thank you. And as I understand it, those things will go out, get public comments, and then we'll probably have, as you look at item number M, somewhere between November 4th and Tuesday, November 9th. We'll likely be convening, depending on where all pieces go, lots of pieces in this process. But likely the first week or so of November, we'll be having another board meeting to evaluate the responses to that. Correct, Ms. Pellos?
That is correct. That's kind of our tentative date. So it'll depend once we have the proposed rules filed with the Texas Register and published, then we'll definitely have a more certain date so we can, and Angelica can pull the board members on that. But that's kind of the date range we're kind of looking at right now.
Well, very good. Unless there are other items that I have missed as we've worked through this robust agenda. Angelica, is there anything I missed?
I think you're good. Unless there's
And
any
this
more
is Katie
items on the next
Bryce.
agenda. I'm sorry.
Sorry, this is Katie Bryce. I was just going to say that we will probably have work group reports to put on the agenda since we didn't make assignments for those groups in this meeting.
Excellent. Excellent. Thank you. Well, is there anything else? Barring any other information there, then we will announce that the meeting is adjourned. We appreciate everyone for your attendance and excited that we had a quorum today. The time is now 11:48. Thank you. Have a wonderful day.